Hi, I'm Nate Charles, and welcome back to another episode of the Rule of Law Brief. So, a couple days ago, I posted a video mentioning that Pete Hegseth is a war criminal, and I laid out the reasons why in that video. I've received a lot of pushback from that commentary, and I want to address it. Some of those people are arguing that the Geneva Conventions don't apply because the United States isn't in a formally declared war. I'm going to speak to this both as an attorney and as someone who served at Joint Special Operations Command and as a Navy SEAL officer. That argument collapses the moment you look at the actual text of the Geneva Conventions. Common Article 2 appears in all four conventions, and it states precisely, the present convention shall apply to all cases of declared war or of any other armed conflict which may arise between two or more of the high contracting parties, even if the state of war is not recognized by one of them. That's the law. The conventions apply not only in declared wars, but in any other armed conflict. And they apply even when one party decides that a war doesn't exist. Political rhetoric cannot override the legal trigger. The conventions attach based on the facts on the ground and not how a government chooses to label an operation. Common Article 2 goes even further and says, the convention shall also apply to all cases of partial or total occupation, even if the said occupation meets with no armed resistance. Again, there's no requirement for a formal declaration of war, and there's no requirement that the hostilities be recognized. And there's no requirement that both sides agree on what the conflict actually means. If armed forces are engaged in actions that meet the definition of an armed conflict or occupation, the Geneva Conventions apply. Now, some people have tried to sidestep that by saying that counterterrorism operations aren't armed conflict between states. That argument fails as well because the drafters of the Geneva Conventions anticipated it. There's a second trigger in Common Article 3. It applies to what the conventions call armed conflict not of an international character. The relevant language states that in case of armed conflict not of an international character occurring in the territory of one of the high contracting parties, each party to the conflict shall be bound to apply, as a minimum, the following provisions. And then it prohibits violence to life or persons, in particular murder of all kinds, cruel treatment and torture, outrages upon personal dignity, and the passing of sentences and the carrying out of executions without previous judgment pronounced by a regularly constituted court. Those are the core minimum standards. That is precisely the provision that makes a no survivors directive unlawful every single time. And this isn't academic or theoretical. The U.S. Supreme Court has weighed in on this directly. In 2006, in Hamdan v. Rumsfeld, the U.S. Supreme Court held that the conflict between the United States and al-Qaeda qualifies as an armed conflict and that, because it's not a classic conflict between states, Common Article 3 applies. The court made it clear that the minimum guarantees of humane treatment and judicial process in Common Article 3 bind the United States even during counterterrorism operations. So there's controlling legal authority at the highest level confirming that the Geneva Conventions do apply even in non-traditional asymmetric counterterrorism operations. Anyone claiming otherwise is ignoring the actual text of the treaties and the controlling U.S. Supreme Court precedent. Now, I also want to address a different kind of pushback, one that is more well-meaning. Some people have argued we shouldn't even concede that these operations were lawful to begin with. Maybe the entire mission was illegal from the outset. And I want to be clear about this. I accept that premise. It is entirely plausible, and in fact, I have already argued that many of these operations violated constitutional requirements, international law, or the UN Charter. That is a very legitimate critique. But that's ultimately a separate legal issue. Whether an operation was lawful at the outset does not dictate whether the Geneva Conventions apply. The conventions do not say humane treatment only applies in lawful wars. That would be ridiculous. They do not say if your government illegally uses force, you're free to mistreat detainees. Again, that's laughable. The conventions were drafted precisely because governments engage in unlawful or questionable uses of force. The protections exist regardless of whether the operation itself was legal at the outset. So while I accept the premise that certain missions may have been unauthorized or illegal, and in fact I actively support that argument, I reject the conclusion that the Geneva Conventions therefore do not apply. That's not how the law works. The protections of Common Article 2 and Common Article 3 attach automatically whenever organized armed force is used. They're unconditional, they're absolute, and they are binding. So the bottom line is this. The Geneva Conventions apply whether military force reaches the threshold of armed conflict, declared or not. They apply even when one side denies that a war exists. They apply in counterterrorism operations. And the U.S. Supreme Court has already held that Common Article 3 applies to conflicts with non-state actors such as al-Qaeda and, if you want to call them that, narco-terrorists. Under those standards, a no-survivor order is illegal every single time. That's the legal reality. And that's the operational reality. Anyone claiming otherwise is either unfamiliar with the law or is attempting to justify conduct that the law expressly prohibits.